Assalamu alaikum warahmatullahi wabarakatuh. Let's make dua inshallah and start. Allahumma ameen. Allahumma anta as-salam minka as-salam tabarakta Darul jalali wal ikram. Allahumma rabbana yassir wa la tu'assir wa tammim bil khair wa bika nasta'in ya fattah. Subhanaka la ilma lana illa ma 'allamtana innaka antal alimul hakim. فسبحان ربك رب العزة عما يصفون والسلام على المرسلين والحمد لله رب العالمين. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. Shall we continue tonight from where we left off on the topic of inheritance? And our last discussion we mentioned concerning the importance of the guidelines in preparation of a will. And we looked at a few things concerning it. And amongst them, we looked at the will and inheritance, what we must have firstly, a drawn up of it. We understand the definitions of a will, the things and the terminologies that we use in a will. Right? For example, who's a testator, what is the estate, and all those small little nitty-gritties that makes up the will that we need to know about in forming a will. So before we can actually write a will, we must know what the will have and entail in it. And even if you have to read one or to analyze one, we must know what it contains. And sometimes the fine print, sometimes in a will, we really didn't understand what is there. So those things were important for us to look at. All right, and what is an Islamic will as opposed to an ordinary will that one would see out there. And an ordinary will a will that is prepared by a state or by a lawyer of a land, a particular country or state, depending on their laws. When we prepare a will, our will is based on two factors. One, the Islamic point of view, the Sharia point of view, and also the view that will fall in line with the laws of the state that will make it easy to adapt this will and to fulfill the requirements of the will, lest the will be determined void. All right? So we looked at those things and what should be placed in our will that will make it important for us to look at the benefits that one will get out of it. For example, we talk about the importance of our missed salah and so on. If we have missed and we have to make qada and compensation for it, our salah, our zakah, about if possible hajj, but the priority will be more on what? Salah. Because hajj is only if we had the means at that point. But prior to all of this is missed salah. The key for the most important things is our salah. All right. Then it will be qurbani and other fidyas and other types of different things like those things. All right. Then we looked at as well as the important aspect when we spoke about, all those points. Then we talk about the aspect of the things that will make a will valid or invalid. Very important. All right. And there are a number of factors that could cause a will to become invalid. And if a will becomes invalid, we're talking about the one-third aspect of it. What happens to that? If that one-third portion becomes invalid by the testator, they say that this holds no ground, then what happens to the will? We say that it could no longer be considered as being valid and cannot be used. So what the portion of that one-third, where does it go? It automatically draws in and adds up to the two-thirds. And therefore, the full amount of whatever you were prepared to be willed will now be going in the total estate as that which the heirs, those who will inherit from you directly by the Quran and Sunnah, will take all of the wealth. So the one-third privilege you have, if you have not taken care in the proper preparation of this will of the one-third, if it is not documented properly and there is some sort of we call lapse on it, it could invalidate the entire portion of that one-third will, and it will go into that, or it may just invalidate that particular clause or portion of it, depending on how you word your will. It all depends on how you word that part of it. All right, so that's very important to know that those things that will invalidate that will become very important in maintaining the will. All right, so we looked at some of those things. All right, and we looked at the things that we mentioned. In particular, that if a will is to make a wasiya will, then the claims, the entire will invalid if some parts of the will therefore becomes what? Invalid. And therefore one must take care and consideration that whatever is in our will, validity is important based on what is placed in that will. All right? Now, we will continue from those points of valid and invalid wills. All right? And we had reached up to page 618 and up to point number 6. Which mentions that, 4, 5, 6, 4, where it mentions here, the will made by a minor or insane are all invalid. If a young person makes a will, a minor, or a person who is insane, we cannot accept their will, because an insane person really cannot make a will, because he will make will for anything he see. He could call it his and say, well, lies mine, he could take that. All right? But that's really what? Being insane. And that therefore invalidate a will, if a person who is a minor or insane. Then we look at a person who makes a will for more than 1/3 of what is there in his estate. That portion can be called the entire will to be, that third portion of the will to be what? Invalid. Or it could be by the consideration of the heirs, those people who have to inherit from the 2/3. If they say, all right, well, let us extend our hand and allow what? Whatever portion from the 2/3 to go towards that, all well and good. So, for example, I will that probably 5 years or 10 years of salat I miss, and I probably woke up to about $60,000 or $70,000 TT, and it crossed the amount I had. Because let's say the first priority is salah, and I'm paying a compensation towards this. All right, and my children are the ones who are inheriting, and they think, well, look, if my father calculate this amount, and the people who work with him, the scholars who work with him say, it's $70,000 there to pay for this, and whatever little addition with zakat or whatever it may be, $70,000, but it crossed the amount of that third. What would the children say? Nah, leave him just like that. If it is that they would consider leaving their father or their mother in a case shortfall in their ibadat and worship. So here it is now, it could invalidate the will. They could say no. Whatever you give dies, it finish. Or they could have consideration and say, oh, look, we love our father, we our mother, take how much of this is needed for that. Because that is neither a debt. You understand? Those things, for example, salah and so on, is not a debt. But if put on the will and needs to be fulfilled, out of consideration, they can extend. But if it's a debt, on the other hand, it is a different thing. A debt means that a person owes money. And if he owes the entire of his estate, then he has to pay the entire of it. He can't hold back anything. That is mandatory. According to the Quran, that is fard. He must fulfill that requirement. As opposed to this. So consideration here is now given to a person if perchance his children, those who are to inherit, whether it's his children or whoever the relatives are, the ones who are to receive, consider, okay, yeah, we give in, we give in. But if they don't give in, then in the light of it, he is at a loss. Or she is at a loss. All right? If the amount of the debt owed by the deceased is so high that its payment leaves nothing for the inheritors, well, so be it. Nothing to be collected there again. All right? So they come out with nothing. Even though the Quran mentions that they have 2/3, but they have no 2/3 if there is nothing to receive. Right? Except, of course, if the debtors and them decide to what? Forgive some debts, then you might get back something. But if they don't forgive anything, all must go. Paying of debt is a priority, especially for the Muslim. We're going to come to understand that just now when we come to finish these invalidations. If the will is made for a particular plot of land, a house, clothes, domestic animals, or something else, and which went out of his or her ownership somehow or wasted or died, then the will becomes invalid and it becomes to that particular thing for which the will was made, and it does not, if it does not exist anymore. In other words, you have a few animals, you die, but by the morning the animals also die. But that was part of your will. They die, and you had that in your will to give somebody. That's the end of it. It doesn't make the entire will valid, but that portion of it becomes invalid. You can't give away anything again if you don't have it. Right? And that goes with every other thing else. You will a house and the entire house burned down. You can't will that again. It's finished. Come to ashes. You can't put it in a jar and say, well, that's your share. Right? It wouldn't work. Because the will would not take that into consideration. It is finished by the end of it. All right? So, consideration is due on these things as well. So, while it may be there, valid up to the point of your existence, when you die and it also finishes, it is out of the will and it no longer becomes valid. You can say, well, take the rest of the money from the estate and build back a house for me, and that is my house, and whatever come after that from the estate is yours. The rest will have to share that. Can't work so. Whatever it is that was gifted or whatever was given out, that has to be as is. Right? We cannot change that really. Or rejuvenate the asset or change around the asset to be something else or share up the asset in a different way. No. All right. Important to this as well, will to a non-Muslim. If we can give to a non-Muslim in our will, meaning that this is placed there and is distributed when a person what? You have died. So you put this in your will. We cannot. We cannot will anything for a non-Muslim according to the Sharia and in preparation of a will. For the hadith of the Rasul sallallahu alaihi wasallam to us from Usama ibn Zaid, he says, Qala Rasulullah sallallahu alaihi wasallam, the Prophet sallallahu alaihi wasallam said that La yarithul Muslim kafira wa la kafiru al Muslima. That a Muslim cannot will to a what? A non-Muslim, a kafir, wal al kafiru, and a kafir cannot will to a Muslim. Hadith from Sahih Bukhari and Sahih Muslim. Right? They cannot get anything on a will. If you want to give them something, you have to give it while you are alive. Give them a gift, or you want to give them any cash or whatever it is, must be whilst you are alive. But you cannot place that in your will and you decease. By Islamic law, it will not be accepted. If, however, it goes to a state law and it is placed on a will, it can be challenged and it may be valid enough in a court of law and they will take it. But what will be the problem? The executioner and the person who testates is that the person who owns his wealth and placed this in his will, he will become liable to what? Receive punishment. Because by that means you're what? Actually giving away and defying the orders of what? Quran and Sunnah. So you put something in your will that is illegal according to the laws of Islam, and you die, by your children, if they are non-Muslims, then they can challenge your will, all well and good, take it to a court, and they might be valid enough to accept it, and say, well, yes, that is found and witnessed by, that this person must get this. But never mind, there was also what? The most important thing was left out there, which was what? The Islamic law that must be applied. And if it is that the children who are there know that this is the case and they don't show consideration, then they put their father or mother in a state of sin, be liable to receive punishment. And that's how dangerous it is when it comes to what? Preparing a will, whether it is what? Lawful, valid, or haram and illegal. All right? Islamic law, and that means the knowledge about it. We may not have all the knowledge, therefore we must seek that knowledge about ilmul waratha from people who are engaged in it, scholars of deens, or people who are at school, or wherever it may be, that you can go and seek this knowledge about how to prepare an Islamic will is very important, because if there's any invalid things in there that may be haram, it may cause danger to that person dying in this will. It may be valid. Yeah. Yeah. Because they can challenge it in the will. They can say that this is in the will. But by Islamic law, it will show that it's wrong. But by the law of the land, it will say that it's right, because it is the owner of this will, who is deceased, did give this as a charity or a gift for whatever it is to this person that is gifted. But what is the clause, whether the state is going to uphold the Islamic law or clause that is placed there or not? And that's up to the state and the individuals and who will challenge the case, the lawyers or whoever it may be, and whether there's proof enough that this person, he died, but he didn't understand it, but how he put this as the clause and they're willing to accept it or not. So it all depends on what goes on in the state and the law and the court. That will determine the end result of that case. So, that's the danger of it. So, as the hadith tells us, La yarithul muslimu al-kafira wa la kafiru al-muslima. They cannot benefit from one another. All right, and likewise, if they want to give us something, a non-Muslim, might be a relative to us, or a parent might be a non-Muslim, in their will, if they die and they put us in there, we cannot take anything. If they have to give it to us, they have to give it to us while they are alive. Hadith makes it very clear. The will works both ways. It's fair enough when the hadith is saying it. You cannot receive from them, you cannot give them, and you can receive from them. Once it's in a will. Once you're alive, you may be able to do whatever you can to make amends or give as you so desire and like. All right? To the will, yeah. So whilst they are alive, you could do otherwise. But once it's in the will and you pass away, finish. Whatever is there will go, according to the law, to become valid or invalid. Next point, looking at if a person for whom the deceased has provided cash or property in his will refuses to accept what was in the will by the maker of the will and says, I am not going to take it. All right? He says, I'm not going to take what you're giving me here. I don't want it. I don't want it. I don't want it from you. Then the will shall become invalid. As such, he will not be able to claim it later on, but if this refusal took place during the lifetime of the maker of the will shall not become invalid because the only valid acceptance or rejection of a will is what comes after death. After death of the maker. Pre-death acceptance or rejection is not valid because my will have it only when I die, then you could see wherever you want. If you don't want it, leave it there. Right? Somebody will take effect otherwise. So invalidate that part of the will, that clause will become what? Abrogated. And whoever's had to get, will get what they have to get. And that excess that will remain will either go to the 2/3 or to some other thing for it. Finish with it right there. But that particular one, if you say, I don't want it, no problem, you don't have to take it. It will go to some other, the 2/3 portion of the remaining, which is for the heirs to inherit, or it can be for some other thing that you may probably want to use it for in the will. So you could say the remainder of that 33.3% could be used for something else. So you want to have a little clause, and the remainders, if there's anything remaining, put it towards the masjid, or put it towards a school, or towards the home, or the old, or something like that. So should in case anybody refuse, whatever remain there is put towards that. To that kind of thing. So some clauses to some effect, you should have that. And this particular one wants to pay attention to this because it is an important aspect of it. A point that you will not see here, I didn't write it down, but it come to mind now, is that whilst preparing a will, consideration must also be given to those things that were given to our children in terms of cash, kind, or whatever it is. When they're small and they're growing up, some parents, they say, well, the grandfather say, well, take $200 and keep it for your son, or my daughter, grandson, or my granddaughter, whoever the case would be. And next one say, take a $500. And the uncle, aunts, everybody giving them money and they're keeping money. Or the grandparent or one of the relatives say, well, I buy a car for him. All right? But you somehow usurp this wealth for yourself during your lifetime with them. You're young growing up, so you keep any money, but you have a need for the money, so you're spending the money too. So, but you never take an account of it, or you have some account somewhere. If this is the case, then that wealth that was theirs will still be theirs, even if they grow older. And that wealth, you utilize it, it is still theirs. So what happens? You have to cater for this in your will as well. That you owe this amount, this amount of monies were collected from my children as gifts, some so and so and so and so and so, amount of so much and so and so much, and what? Pay out this on my estate. Sometimes you may not even consider that small money, that small $5 or $10 or $20 or whatever they get. Whatever our children receive is theirs. And we cannot take term leak and ownership policy. Well, I as the father, I go just hold it for you and I spend it. But whatever they receive as theirs is theirs. And that is important and tells us the next aspect of our will. That a child in the process of being born or a child just born, they are all entitled to receive. If their father dies or their mother dies, they can what? Receive wealth. Or if a relative died, a brother or sister died, and that child is related to that, then they what? Are still entitled to receive as a baby. So it shows us that tamlik and ownership for a child from even that stage is what? Valid. So if they can receive that and they receive gifts as well from any relative, it belongs to them. It does not belong to us. We cannot say, well, I'm minding them and taking care of them. That is a haq and a right and a responsibility that we have to do as parents or as guardians, as the case would be. But what belongs to them, Quran always makes it very clear and warning against usurping the wealth of what? The orphans and the yatim, the poor ones and so on, because whatever wealth they have We cannot take advantage to our own likeness and use it as we so feel. And even our own children's wealth, whilst they are from birth growing up, if they ever receive anything, it is also theirs. Cannot take it and use it for ourselves. And if it is theirs, then it is for them. What about if we as parents give to them? I know sometimes you keep putting a little money in the account for them or wherever you have the money saving. And sometimes, after giving it to them, you get a use. You find the money account get big. So that's a good few thousand well. And you have use for this money now. You want to buy something with their money. Whatever you give to them, it becomes what? Theirs. Whether it's you, whether it's a relative, you still owe it to them. So you have to what? Pay it back at some point in time. And if you didn't pay it back at any point in time in your lifetime, you must know that you must put this in your will, that it must be repaid. All right? Because that is how serious it is when it comes to what? Wealth. We might consider it, well, yeah, I was just trying to help them to grow a little bit in wealth. But once you give it, and ownership pass, can't take it back. It belongs to them. However, there is a case where if they grow old and they see this in the will, they could say, we forgive this debt. They can forgive the debt provided that the person passes away, or if he goes to them prior to preparing the will and asks for forgiveness for these things, and the children will to forgive it, no problem. But if they say no, put it in the will, find the money and pay it. They don't have no choice but to pay it back. All right? Because there is no consideration with money, whether it's family or not family. When it comes to money, it has to be straightforward, especially when it comes to this deen of Islam. Allah subhanahu wa ta'ala makes it a very important and integral part when it comes to money. And it tells us clearly here, when we understand that, how dangerous wealth is. Even with your own children, money that we may consider just, out of kindness to do something for them, the same money could be a danger for us in for us later on in our lives, or even when we leave this world, if it is not what? Executed and distributed properly. All right, the next point mentioned here, it says, a will which excludes one's entitled heir, a person who is there to receive from the 2/3 from the inheritance, or which seeks to curtail the heir's share in it. In other words, you're cutting down the amount, or putting them in a small portion in the will, is invalid. Executing such a will is categorically impermissible. Moreover, making such a will is a sin as well. If there is a person in amongst our family members who is there and entitled to a will, then that person must be granted a will. However, we come to the next point. A person makes a will for his or her heir, for example, a mother, father, husband, son, or others, then this will shall be invalid because the Sharia has already in itself fixed the share of every heir in the inheritance. You can't say, well, you're giving them a share in the 1/3 and they also have to collect from what? The 2/3 portion of the wealth again. It can't work. It'll be invalid right there. Once they fall within the category of receiving, and that's why it's important that we must know this. We must know this. If a person has children from one marriage and a next marriage, right? And he takes, well, he said, if I leave them with this wealth in this family alone, for what? His wealth, eh? So, I have children with this woman and I have children with the next woman. And prior marriage, I have 4 children, I have 4 in this marriage. And he only prepared, and in the first part of the will, the 1/3, he puts for the first set of children, he had what? Nothing. But in the second set of children he has with the second wife, he does what? Only give them in the will, but in the first set, he put them in the 1/3. Invalid right there, because they are all rightfully his children, and they will all have to receive. He will say, well, them never do nothing, and they had real confusion before, and you say, strike them off. I don't want to talk to them anymore. Them children never like me because I had a next family with children. They don't want to hear about me. There are cases like that where, the first wife and children, they come out what? Disappear from the whole situation of your life. But you see, when it comes to inheritance, they could reappear, and they have to reappear. So it even tells us how the relationship in the way we deal with people, especially our children, is very important. However, there may be a case where a child could be left out of the will. One, if they are non-Muslim. Two, if they are disobedient, meaning that they are disobedient to the extent that they will take your money knowingly and go and gamble your money. They'll drink out your money. They will do things with your money that will be destructive to the wealth and make you become a sinner instead. So you saving your money all the while to do good deeds and charity to help people with your money. Inheritance come along, but what happens now? This particular individual is like this. Get proof, get validity, show that this person cannot be there in this will because of this. And it may be in a clause, exclude this individual because of this behavior. That is also to be determined and confirmed whether that individual should be left out. We can take our own personal consideration. You know what, say, well, I really don't like him, so I go just put him in a will. He has behaved bad. He does lie, or do this or do that. No, that won't work. It must be such a valid reason for exclusion. And it must be approved according to the Islamic Sharia. Get some scholars' advice and make sure it is valid enough for such an exclusion. Otherwise, you cannot just do it on your own whims and choice and fancies. All right? But it can, but only dependent on those considerations. All right? However, if the deceased has no heir other than that particular heir, or if the rest of the heirs are willing to forego their rightful share, then it will be allowed. But the permission given by a person insane or minor is not valid. Only sane and adult heirs can, and if so wish, give out from their own respective share. And this also brings us to our next point in terms of, when a person compromises themselves in a relationship of giving what is right. For example, many a times daughters, women on the whole, they are affected the most from inheritance, They somehow out of the other get strike off, and sons always seem to have the what? Position of getting everything. In the Quran, that is never the case. Allah subhanahu wa ta'ala, Surah Nisa tells us clearly that they have a portion to collect. They have to collect that portion and must not be left out of our will. If you say, well, she have a rich husband, she can take care of she. That has nothing to do with what we have to say. It's what Allah mentions. And that tells us, a person can be filthy rich with any amount of wealth. And they have to receive, they have to receive. They don't want to forego it, it's up to them. Or give it to their brother or to give it to somebody else. They could do that on their own. But our responsibility is not to exclude. That is the order of Allah that we have to fulfill. That we don't have a choice in that matter. Right? And in relationship to it, if we have to give our children as well, and they're not part of the inheritance, for example, our daughters, they cannot be in the will of the 1/3. And they're getting a smaller portion in the what? 2/3. And they might be desperate and need help. So what you have to do? Take care of your daughters and your women folk whilst you're alive. That is our responsibility anyway. To take care of our daughters whilst we are alive. Do not let it go by and we have not taken care of our daughters in particular. Because many a times, we see cases like that where the girls themselves, women on the whole, they are the ones who are always on the what? Losing end in inheritance. All right? And there are some also who are very witty as well. They might take over everything as well if they don't really what we're doing. But in particular, they are the ones they will think that we're losing end. But the Quran has always, Allah subhanahu wa ta'ala has been an advocate because He's the Creator. He knows what is best for all of us, and He has placed it clearly in the Quran. And in the Hadith, the Rasul tells us that this is the way the will is drawn up, that women are also included in every aspect of the distribution. All right? If a testator or a maker of a will takes it back within his lifetime, for example, he says, I take this will back, or I cancel this will, then that will, is rendered invalid, and this will may not be executed. So once he says, I see all other guy, nothing for me again. Finish. Then you have no will. Once he says this, he has witness and he pulls it out. He says there is no will for the nothing again, that is it, finish. Except on the throes of death or somewhere he cannot what? He's in a state of being invalid. He can't, he's not thinking himself, he's gone insane or something like that. Out of pain or something causing that, then it's a different story. He could say in him one at a time. But once he put it in the will before, he go insane, that ain't going to change nothing in the will. Once you could prove that he's what? Insane. All right? If the deceased made a will for his killer, All right, he made a will, and part of the will is the person who what? Kill him. All right? Or after being injured by him or something like that, the situation presents two solutions. That if the killer was not a minor or insane, the will is invalid. Because an insane person can't hold him, غير معلوم, he doesn't know better. He don't understand anything. So if he kills someone, he get away scot-free as well. Because out of insanity. So it will not invalidate the will because of that. All right? Or minor with due consideration, maybe based on certain things, may not be what invalidate the will. However, the killer is a sane person, knowing what they're doing, consciously, not accidentally. Consciously, some jurists of the opinion, if it's accidental as well, still. Because we don't know that accidental was what? Really what? Accidental. All right? So the possibility, under such consideration, the killer will not get anything. All right? Come out of the will? Totally. All right? And that is the law, the hadith narrated by Abu Hurairah. He says, Qala Rasulullah sallallahu alayhi wa sallam. He says, Al-qatilu la yarith. Hadith on Tirmizi says that the killer will not inherit. All right? Hadith on Tirmizi. So, there it is clear cut. A killer receives nothing. All right? And that is even goes some days, nowadays people, Allah save us from such things, Once a child knows that they're in the will and they want the money too fast, they take action with their hands. And may Allah save us some children like that, or people who we have on our will with the mentality like that, might want to get money in advance. But they have no card to withdraw, so they withdraw your life instead. In such a case, invalid immediately. So we make that known, and it is also known in the Sharia. All right? If it cannot be proven, it cannot be held by an state, for example, the state civil, that was actually an accident, that didn't happen what? By accident that took place. According to Islam, there's a possibility that he should not be given anything, even if it is accidental. Even if it is accidental. All right? Making a will for a type of people to receive, for types of people to receive from the inheritance, people who openly disobey Allah, I mentioned this before, and are involved in all sorts of sinful activities and reprehensible makruh actions. There is an overwhelming likelihood that these people will spend whatever they receive from the deceased on these very activities. If this deceased has made a will for this type of a person, his share will certainly be given to him in accordance with the rules of the will. He can receive it. But the maker of the will is going to end up a sinner. So you can't say, well, I'm a real partner, but he's a drinking partner, he doesn't drink. But he still has mouth so and so, so I give him everything and he will. Can't do that to waste your money like that? Cannot. Right? A wife cannot, at this point then for her meher, at the time of that, ask for her meher. All right? This will not be correct without the permission of all the heirs, because for giving this during death for an heir, the husband in this instant will be depriving others of their rights. So at the point of death, he can't do it. She could do it before that, not at the point of death. And even in the will, once it's there, it's a debt. All right? If she does want to give it up and then take it, receive it and then give it back to anybody, she can do that. No problem with that. All right? So, in the mirath, we have discussed most of these preconditions here concerning most of it in preparation of the 1/3 part of it. Now we're going on to the real important aspect of it. The aspect which deals with the 2/3 of the will. That 2/3 portion of the will, Quran and Sunnah and Islamic jurists have already determined what is to be given to who are the heirs or the inheritors. So it dealt so far with wasiyah. Make a will, you can make a will free choice and give whoever you like and whatever you like when you want to. Do whatever you want with it. In particular, look after your ibadat and make sure you cover all your worship, your short forms of your worship, your limited amount in your worship and so on. You cover those things, clear of those things, you have that choice in your 1/3. But in the remaining portion of your wealth, now comes the part where Allah's decree come above everything else. And the Rasul sallallahu alayhi wasallam, in a hadith narrated by Anas radiallahu ta'ala anhu, he says, Qala Rasulullah sallallahu alayhi wasallam, Man qata'a miratha, whoever cuts off someone who has warithihi, who has intention to receive inheritance, qata Allahu mirathahu min al-jannah. Allah cuts off his inheritance for Jannah as well. That individual who dies and makes a will and cuts off anyone, Allah cuts him off from Jannah too. And some of the commentators of hadith mention this may be for a particular period of time, or it could be for whatever determined time. Allahu alam, Allah knows best. So the danger of wealth is that we make wills, but there's a part of a will that when it comes to the wiratha, the one that who actually have to receive, you cannot take them out of the will. And the hadith clearly tells us that clearly here, that if you take them out, you take yourself out of paradise. You know, you could do it legally by the law of the land, whatever you choose and whatever choice you have, or do whatever you like with your wealth, and say, don't give this person, you do it like that, but know what you're putting yourself in. Imagine the own wealth that you have. This is where we say you have no choice. We have no choice in the matter. It is left up to Allah and the Rasul in the decisions that are placed in the Quran and Hadith. Not our choice. And therefore, wealth, when examined like this, you know, when we examine wealth like this and understand what is the big danger of wealth, and in the aspect of the deen that Allah subhanahu wa ta'ala has placed wealth, it is one of the most dangerous things. We might enjoy wealth. We might work hard for wealth. But it is the same wealth that can deprive us of paradise. The same wealth. The same enjoyments that we want out of wealth. You know, we could pile up by the millions of dollars. Pile it up. With the hope and expectation that our children will benefit from it. With the hope and expectation that those people who will inherit. And sometimes we don't even think so far. We don't even think so far. But the very danger that sometimes we sacrifice all our salah, we sacrifice our whole life of deen, of learning Islam and living Islam for this said wealth. And this same said wealth is going to knock us out of the road towards Jannah. The same wealth. May Allah subhanahu wa ta'ala save us from that. That a person works so hard, and when he reaches to this point, he gets to realize that if he takes his wealth and at this point in time and puts it in the wrong channel, imagine you serve Allah all your life, and when you reach this day, you take your will and turn it upside down, away from the Sharia. Everything else what? Your whole life, all of the efforts went upside down. Everything else is thrown abroad and thrown to waste. So efforts now is to understand clearly, to accept the Quran. And this is one of the biggest aspects that cause conflicts in our ummah today. Amongst the Muslims today, many homes and many families do not accept what the Quran says when it comes to the Islamic laws of inheritance. Why she should get less, or I should get more, or whichever is the case is, what portion you have to receive, you always look at who have to get and what they get in more. And that is not for us to determine. It is Allah to determine. And Allah subhanahu wa ta'ala, He mentions to us in the Quran concerning these things now. He says, أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم للرجال نصيب مما ترك الوالدان والأقربون وللنساء نصيب مما ترك الوالدان والأقربون مما قل منه أو كث نصيبا مفروضا. So he says, للرجال, for men is a portion, نصيب مما ترك الوالدان, from what his what? Family, his parents leave behind, والأقربون, and his close relatives. وَلِلنِّسَاءِ, and for the women is a portion, مِمَّا تَرَكَ الْوَلَدَانِ. Allah subhanahu wa ta'ala separated the both of them. He didn't say men and women. He said men and he said women. He clears this in the Quran. For them is also a portion from their parents and from their relatives. They are also included in this inheritance of this two portion. He says, مِمَّا قَلَّ, whereas a little bit, Aw kathura, or if it is plenty. Whether the portion is a little or whether it is a great portion, they have a portion to receive. Don't underestimate the portions. He says, don't consider that small thing, I just give it, never give it, let me get, they feel bad, they want it. No, Allah says, whether it's a small amount or a big amount, it is a portion that Allah has willed. And He says, Nasiban mafruḍa. It is a portion that Allah has made determined. That word determined doesn't describe actually the actual word mafruḍa. Mafruḍan comes from the word fardun, which is compulsory. Mafruḍa. Allah says, this portion Allah has made it binding to give. Not our choice, but what Allah has made binding. And what is binding is those portions that He described, and He described them further on. But this particular part of this verse, verse 7 of Surah Nisa, is telling us clearly here that a will in that portion of our wealth is fard. And that will is what Allah has already prepared. That is fard, to be upheld. So Allah is showing us, if we are true believers and obedient servants of Allah, and we follow all our 5 times daily salat, because it's fard to follow that. We fulfill the rights of the fard. It is fard to pay our zakat, so we pay zakat. It is fard to fast, compulsory to fast, so we fast. When Hajj becomes compulsory and fard upon us, we go for Hajj. When it comes to mirath now, we didn't see that as fard. Allah says it was nasiban mafruḍa. This portion is also fard. So we earn in wealth, but when it comes fard to spend it, when you die, it is fard to distribute like how Allah said to distribute it. Can't change that order. The minute we change that order, we break the law and the faraid that Allah has placed upon it, the compulsory aspect that Allah has placed on it. So we break the direct command of Allah. That's a serious what? Abrogation. And that's a serious charge that a person would take what is fard and make their own choice in it. A person's 2 rakat salat fajr is fard. Could we make it 3? Could we make it 4, 5, 6? No, we can't. Allah says only 2, and it could be what? 2. If Allah says, this is the portion that you must give to your son, this is the portion you must give to your daughter, this is the amount your wife must receive, this is the amount must be given for so and so and so, then that's it. We can't say otherwise, no. Leave out this one or put that one or take out this amount, make it less amount, bigger amount. We can't do that. Whatever Allah has made fard in this will is fard. And that is something that we have to come to terms and teach our children, or teach those who are going to receive from us, and those who have to receive inheritance must learn this subject. I'm not saying that they learn the calculations and every aspect of it, but we must come to terms with what the Quran has in it and be willing to accept it for the sake and the pleasure of Allah, because sometimes we see that children go in direct contravene to what Allah mentioned in the Quran when it comes to what? Inheritance. And so the warning is taken here for us to understand how important it is to observe the laws of inheritance according to the laws of Allah subhanahu wa ta'ala. And ayats that come afterwards, 8 and 9, it talks about وَإِذَا الْحَضَرَ الْقِسْمَةُ أُولُو الْقُرْبَى وَالْيَتَامَى وَالْمَسَاكِينِ فَارْزُقْهُمْ. You know, those who are near and dear relatives, orphan and relatives and so on, who are there, and they need something, give them from your wanted portion. But the first part of it talks about what? Relatives. That those husband and men and women, they are to receive from their parents wealth. Clear cut, without any doubt. And hence, it puts us in a position where one will have to come to realize, you know what, I'm working and I'm living and I sacrifice so much and I die and still my wealth works against me. And still my wealth works against me. The ayahs that come and give us the actual distribution, which we discuss next class, inshallah, it tells us, verse 11, it says, Bismillahir Rahmanir Rahim, Yusikumullahu fi awladikum lidhakari mithla haddil unthayain. First ayat, verse 11, Surah Nisa. It says, Allah directs you concerning your children. For a male, there is a share equal to that of 2 females. First fraction or the first distribution is for a male is a share equal to that of 2 females. So it tells you that a male will receive what 2 females will receive. And if there was, so it says the proportion will be 1 share to a girl, 2 shares to a boy. Quran places in a very, Allah subhanahu wa ta'ala writes this and places first in the ayat of Quran in a very what? Particular way. Alright? Why he puts it like this? When he can just say what? 1 by 2. 1 for you and 2 for you. But then he says what? A male share is really equal to that of 2 females. This is the balagha. The language of the Quran is such a beautiful thing. Subhanallah. You know, if you ask to put this in a normal form, you'll put it like that, you'll say, all right, a person, a boy will receive 2 shares, a girl will receive 1 share. Finish. But Allah says, that boy share is equal to that of 2 female shares. And it means 1 by 2. Then he continues and says, فَإِن كُنَّ نِسَاءً فَوْقَ اثْنَتَيْنِ فَلَهُنَّ ثُلُثَا مَا تَرَكَ. But if there is only women, meaning girls, more than 2, then they get 2/3 of what one left behind out of your will. Quran makes it clear. The girls now receive 2/3 of the entire portion of that what? Wealth. Of the 2/3. And if she is 1, she gets half. 1 half. Alright? We'll stop there today, inshallah. No, because I want to go into this in details, one by one, and describe them, what they are about. And then we'll talk about preparation of our will and drop our will and look at example of cases, a few cases, inshallah. But for this, we're going to just go through the ayats, understand what the ayats are saying. And you know, many people think about this Quran, talks about fractions, you know. And it's a very important part of our arithmetic that we must learn, or math, that we must learn about these fractions and the distributions. But this is not all it, because every one of us here in this room, and who are viewing as well, you know, every one of us are an individual case by ourselves. An individual case by ourselves, because each one of us, our relationship and who will inherit from us will be totally different. So therefore, how does the Quran accommodate this and the Hadith accommodate this, and how does Islam view it? And it is accommodating for every single case. The cases that you could think about in your mind, that and more. Every single case. May Allah subhanahu wa ta'ala make it easy for us, inshallah, to continue, inshallah. From here. Let's make dua, inshallah. Allahumma ameen. اللهم انت السلام ومنك السلام تباركت يا ذا الجلال والاكرام سمعنا واطعنا غفرانك ربنا واليك المصير اللهم ربنا يسر ولا تعسر وتمم بالخير اللهم نسالك الجنه جنه الفردوس ونعوذ بك من النار ربنا آتنا في الدنيا حسنه وفي الاخره حسنه وقنا عذاب النار فسبحان ربك رب العزه عما يصفون والسلام على المرسلين والحمد لله رب العالمين.